Hi there. If you've been following this YouTube channel, you know that one of the things I've talked about is the types of hearings that the Maryland court system is conducting right now during the response to the COVID-19 virus. One of those types of hearings are emergency protective order hearings. And recently I participated in one where I represented the respondent, who's essentially the defendant in such an action. Now, fortunately, we won, which was the right result. No protective order, no temporary protective order was even granted, which was a great relief to my client. But there were a number of kind of interesting issues that the way the court conducted the hearing and the kind of the procedural impact of the COVID-19 virus shutdown impacted how everything happened. So this was a temporary protective order in a district court in Maryland, where my client was instructed to call a hotline from the courthouse to learn when and how their temporary protective order hearing would be conducted. The interim protective order that they had been served with by the Sheriff's Department over the weekend indicated that the temporary protective order hearing would be heard at 12:50 p.m. When my client called into the hotline, we learned for the first time that the hearing would be conducted at 11:30 a.m. And not only that, it was going to be conducted by telephone only, no video conference, which struck me as odd. In addition to learning that the hearing time had changed, we also learned that any exhibits that we wanted to submit to the court for its consideration needed to be submitted electronically in advance via MDEC. That's not normally done in protective order hearings in my experience, but it allowed me the opportunity to see what was going to be presented against my client in advance, review those exhibits, and discuss them with my client, which was invaluable and helped me be very prepared for the allegations that were to come. Interestingly enough, for all my attorney friends out there, the judge stated that they reviewed these submitted exhibits via MDEC, but once the court gave its ruling, the court stated that anything that wasn't formally introduced and admitted wasn't going to be considered as evidence at all in the decision. So on one hand, the court saw these exhibits, knew what they were photographs and there were some other documents, but stated that they weren't going to consider that in the decision, which I thought was very interesting. Also, all of the testimony was conducted by trial. Again, for my attorney friends out there, assessing, being able to see a witness, a party testify to assess body language, credibility, that's one of the court's, very kind of underrated but important tools. And that wasn't available in this situation. The petitioner testified via telephone to the judge first. I cross-examined. My client then testified in response. Opposing counsel cross-examined, and the judge, couldn't see whether anyone else was in the room, whether there was coaching, whether, any types of nervousness. It was very interesting to me. Also, when someone's testifying via telephone, it's a little bit difficult to object and be seen without standing up at trial table and the court being able to interrupt the testimony. So there was, on a number of occasions, an objection that I made that the petitioner continued to testify until the court stopped, backed them up. And that happens in regular trials, but went on a little long for my taste in the telephone hearing. Overall, of course, my client won, so there was not an issue of a temporary protective order being granted. There was no denial of access to the child in question, and which was the right result, of course, in my opinion. But there's a couple issues there that had I not been successful for my client, would have left me very frustrated in terms of how this hearing was conducted and whether my client got a fair shake. And I imagine that the petitioner is frustrated as well. But anyway, I wanted to share this information with everyone. It was my first experience in a contested remote hearing, certainly my first experience with a contested telephone hearing and not a video hearing. And I'll be sharing this with all my colleagues kind of personally as well. But if you have any questions about a protective order hearing or my experience in a contested telephone hearing in the state of Maryland, don't hesitate to contact my office, Weinberg Schwartz, at 410-997-0203. If you have any questions about me personally, all the links to my social media, my LinkedIn account, my Twitter account, and my Instagram page are all in the description of this video below. And as always, I'd really appreciate it if you like this video, comment on it, and share it with all your friends. Have a good one.